My name is BrianT. I'm a staff attorney with the Inter-American Commission on Human Rights in Washington, D.C., with the Organization of the United States. And we have a number of very well-qualified panelists who are going to speak on the issue of international intervention today. Perhaps I can start by introducing the panelists. To my left is Hans-Georg Strohmeyer, who is currently a policy advisor in the U.S. Office for the Coordination of Humanitarian Affairs. Mrs. Strohmeyer served as both the deputy and active principal legal advisor to the United Nations Transitional Administration in East Timor between October of 1999 and June of this year. He also served as legal advisor to the Special Representative of the Secretary General in Kosovo from June to August of 1999, and as rule of law advisor to the United Nations Office of the High Commissioner for Human Rights and the Office of the High Representative in Bosnia and Herzegovina from July 1996 to December 1998. And he will be speaking about the transitional administration in East Timor. That will be the focus of his presentation. To my right is, my immediate right is Professor Diane Heyman, and she's a professor of law at the University of California at Davis. Professor Heyman, her practice and her field focuses on international criminal law, international humanitarian law, and human rights law. And she will be speaking today, focusing principally on Sierra Leone and developments that occurred in Sierra Leone. And on my far right is Professor Dr. Barry McCullough, who is with the Department of Political Science at Okanagan University in British Columbia. And Dr. McCullough has his PhD in constitutional law from the University of London in the UK, and a B.Lit from Oxford University. Right now his current research has been principally in the area of Kosovo, as well as constitutional law and political philosophy. And he'll be speaking focusing principally on Kosovo. And then, time permitting, I propose to say a few words about Cambodia and the current efforts that are being made to establish a tribunal to try officials with the former Khmer Rouge regime in Cambodia. Prior to turning the discussion over to my fellow panelists, I thought I would say a couple of opening words about international intervention, just to highlight the fact that the doctrine over the last number of years has assumed an increasingly prominent and significant role, both in terms of international discourse, but also in terms of actual practical action by states and by the United Nations. And that's become clear in the three incidents that I've mentioned today: Sierra Leone, the East Timor, and Kosovo. The development, what has been reflected in and really has been to a large extent prompted by the agenda of the current United Nations Secretary General. In his September 1999 address to the General Assembly, Secretary General Annan had identified as the core challenge to the United Nations and specifically to the Security Council to forge unity, and these are his words, to forge unity behind the principle that massive and systematic violations of human rights, wherever they may take place, should not be allowed to stand. And the Secretary General repeated this challenge, I think most recently in his Millennium Report, where he again called upon UN member states to unite in the pursuit of more effective policies to stop murder and egregious violations of human rights. And of course, there are a number of aspects of intervention that have been particularly controversial. One being really the modes of intervention, and the most controversial mode being armed intervention. And this certainly has been recognized and debated quite extensively among international scholars and individuals who work in the field, principally because of the implications that international intervention presents for the traditional principles of state sovereignty and the principle of non-intervention in matters essentially within domestic jurisdictions of states. And so this is one of the aspects that you can see comes out of the experience of these three incidents. What is the basis for the authority of the international community to intervene, and in particular to use armed means to intervene? A second aspect of the intervention question is the question of post-intervention reconciliation, administration, and the question of what happens after the armed conflict is finished. And there's a question about civil administration, and in particular the question about bringing to justice individuals who were responsible for the atrocities that the intervention was intended to stop. And this is the other fascinating development that we've seen common, I think, to all three of these interventions, is that you don't have the intervention alone, but there's also a recognition that the intervention has to be accompanied by some mechanism that will bring individual accountability for the types of atrocities and violations of international humanitarian law that gave rise to the need for the international community to intervene in the first place. This development was galvanized essentially by the ad hoc tribunals for the former Yugoslavia and Rwanda, but now we've seen it becoming almost a pattern in terms of intervention being coupled with the need to achieve accountability by some means. So with those comments, perhaps I could turn the panel over to Professor McCullough to give some words about the Kosovo experience.
Okay, thank you very much. To begin with, can people hear me at the back? Is that okay? I'd like to take this opportunity to thank BrianT for facilitating my participation in this and for his efforts on our behalf. The topic strikes me as an embracing one, the evolving dynamics of intervention, international intervention, and just the emphasis upon dynamics here makes me wonder whether or not my comments will be particularly appropriate, given that I want to give some sort of still shots frozen in time of what actually has transpired in Kosovo. Therefore, I wonder if my cinematography is going to be really up to speed. In any event, what I want to do is to look at two different types of intervention. I want to look at military and legal intervention and the aftermath of that involvement in Kosovo. It seems to me that some of the things that should be said by way of that is to comment a bit about the background of the dispute there. I'd like to end with some residual comments, and on the way to reaching those residual comments, talk a bit about the military involvement and then also the legal involvement in Kosovo. As far as the background is concerned, I don't think that we can meaningfully discuss the tragedy of Kosovo without saying something about the disintegration of the former Yugoslavia. And without discussing these in depth, some of the highlights that stood behind that disintegration undoubtedly were the precipitous recognition by Germany of Croatia and Slovenia, also the debt crisis inside Yugoslavia, and very importantly, the absence of any democratic institutions inside the former Yugoslavia that would have facilitated conflict resolution in that state. And finally, but certainly not leastly, the fervent nationalism inside the SFRY that was exploited in the absence of democratic institutions that would have resolved conflict or helped resolve conflict. With these 4 points in mind, I think one can see a bridge that led to the tragedy of Bosnia, the imbroglio of Bosnia, the implosion of that republic, and the road that led from the disintegration of Bosnia, the war in Bosnia, to Kosovo, went right through the Dayton Agreement. And as many of you are familiar, the Dayton Agreement, for all its merit, was well known for the omission of making many remarks and comments about Kosovo. And the effect of that omission was to really cut the knees out from under BrianT, who was aiming at a somewhat passive resolution of the conflict between the formerly autonomous state of the province of Kosovo and Serbia proper. So with his knees cut out from under him, the KLA became radicalized. It was a deep cynicism, as I'm sure many of you are aware, in the among constituents of Kosovo, Albanian Kosovars, that a passive approach to resolving this conflict was going to work. The radicalization of the KLA led to an escalation of conflict in 1998 and shortly before that, but it reached its most critical moment on January the 15th of 1999 with the massacre in Rača, in which 45 alleged civilians were massacred by Serbian troops. What this did, in the words of others, was to send off warning bells or warning signals throughout Western capitals, and it resulted in the convening of the Rambouillet Conference. The Rambouillet Conference was, again, as we're familiar, was unsuccessful in bringing the two disputants to a resolution. And shortly thereafter, the disintegration of that, there was the escalation of hostilities and launching of a campaign by Serbians on March 20th, 1999 against the Kosovars in Kosovo. March 24th, then you have NATO airstrikes. And so that leads me to the first major engagement here of international intervention. The rationalization provided by NATO for its attack upon Kosovo was given in different press releases as averting a humanitarian catastrophe, ensuring stability in the region, and also maintaining the credibility of NATO. What is really striking from all of this is that there was never, so far as I've been able to tell, any real attempt on the part of NATO to, in terms of international law, justify its behavior in the language of international law. If we're going to assess the authority of NATO's actions in that region of the world at that time, I see no other recourse but to fall back upon the UN Charter, Articles 51 particularly, but also Articles 2, 4, and 2, 7. And Article 51 makes it quite clear that the permissible use of force is restricted to self-defense of a member, and also actions undertaken by the Security Council aimed at securing peace in the region. The consequence of that is that I think we're driven inevitably to the conclusion that, strictly speaking, the act taken by NATO is illegal. The kinds of counter-arguments that you hear from time to time regarding that statement that I've just made are somewhat different, but two different ones that I've encountered are the following: that there was a kind of an objective regime that was established by the 4 resolutions that were passed by the Security Council that had a bearing upon what was taking place in Kosovo. 3 of these resolutions took place prior to the war, and 1 resolution took place at the very end of the war and helped facilitate the ending of it. But if you look at that counter-argument, the so-called objective regime, it's quite clear that none of these resolutions, neither prospectively nor retrospectively, actually legalize or authorize the bombing that took place. Another counter-argument that is sometimes made is that embedded in the UN Charter is a strong principle or doctrine of sovereignty. And of course, over the years, this doctrine of sovereignty, or state sovereignty, has been eroded. It's been eroded because of the development in the field of human rights. It's been eroded by environmental concern. It's been eroded by considerations of economics. As for replying to at least some of this argument that would say the doctrine of sovereignty has really transformed or modified the legal spin or understanding that we would have of the UN Charter, I think we should say that whatever consensus may have arisen over the field of human rights, there is no consensus on human rights that justify multilateral intervention without security approval. And if you think of that, I think that you you see that nation states like Russia or China, and even a NATO partner such as Germany, has made it very clear that it does not want the intervention in Kosovo to be viewed as a precedent for future engagement. I think those three examples make the point that this counter-argument is not going to work based upon human rights. Human rights initiatives have expanded, and there's a growing consensus in this field, but there's no consensus that allows us to infer justified military intervention without Security Council approval. Another argument that is sometimes given relates to the economic constraints that have eroded the sovereignty principle, and I'd like to just say that I think the comments of Jeffrey Garrett in a recent publication are very apt here. Whatever constraints in government policy that may arise owing to global trade or multinationalization of production or internationalization of financial markets, these constraints are much weaker and much less pervasive than is often thought. So I want to leave the question of the authority of a NATO engagement at that, saying that I think it was illegal, and just address briefly the modalities or way in which it used its alleged authority or its power. Most of you will, I suppose, be familiar with how extensive the operation was. There were 27,000 sorties that were made over Serbia at that time. 23,000 bombs or missiles were dropped. And the damage inflicted, it varies in terms of the conservative estimates you get of $30 billion worth of damage, that's the EU estimate, to $100 billion worth of damage being the Yugoslav estimate. In the post-war period, we went through certainly kind of a transitional phase with Resolution 1244 of the Security Council. What that resolution provided for was a civilian and security presence in the state of Kosovo. The civilian presence was really made up of the United Nations mission in Kosovo, UNMIK, and it was headed by Dr. Bernard Kouchner. The security presence was provided by 50,000 KFOR troops. Now, what we can say, I think, is that if we follow a Hobbesian definition of peace, which is the absence of war, what we have in Kosovo today is peace. But it's precipitous and unwarranted of us to say that we now have real security. For instance, Dr. Bernard Kouchner has said that the Roma and Serb populations of Kosovo are still subject to great personal security risks. Now just moving on to the legal intervention. The authority behind the legal intervention was Security Council Resolution 827, which in turn was based upon Chapter 7 of the United Nations Charter. And the Security Council Resolution 827 established the statute of the International Criminal Tribunal for the former Yugoslavia. The jurisdiction that it provided was to prosecute offenders, those who were thought to have committed grave breaches of the Geneva Conventions, violations of laws or customs of war, genocide, or crimes against humanity. In talking about these different types of offenses, it's important to distinguish between those that apply to international armed conflict and those that apply to internal armed conflict. Grave breaches of the Geneva Conventions do not apply to internal armed conflict. And I think that that's instructive for appreciating the way in which the court has subsequently gone about trying to implement the terms of the statute in Kosovo. So if we look at what has actually taken place with the Hague Court in Kosovo, we find that of 37 indictments that had been laid by the Hague Court down to, I believe it was May of 2000, 37 indictments, only one of those has anything at all to do with Kosovo. And the charges that were laid in connection with that were against Milosevic and four other senior colleagues of Milosevic. The charges that were laid were in connection with violations of the laws and customs of war and crimes against humanity. So you see that the Hague the Hague Court has restricted its indictments to the range of charges that it could lay, given that it was an internal armed conflict. In the spring of this year, it seems that there was beginning to occur in the minds of the administrative officials of UNMIC, especially headed by Dr. Bernard Kushner, a sense that something had to change in regard to the prosecution that was taking place in Kosovo. He suggested that there be set up an ethnic and war crimes court inside Kosovo to supplement the work of the Hague Court. So in my research, trying to track down information on this, and it was very difficult to get hold of information because most of it just came out in press clippings. What we find is that well, there's very little to find, so I contacted the legal office of the United Nations, contacted it by phone, and this is not meant as a criticism of the legal offices, but the first person I talked to really didn't know what was going on with respect to this ethnic and war crimes court that was to supplement the Hague Court. However, he suggested that I contact another person, and I was unsuccessful in getting information back from that individual, but was told to take a look at the regulations of the UNMIC. So I did that. He said if there's any authorization to establish this type of court, you will find it there. Well, when I researched it, I found nothing. Nonetheless, as I persisted in doing more research, it was quite evident that something was happening inside Kosovo in addition to the work that was being done by the Hague Court. What seems to be going on right now is that the United Nations mission in Kosovo is attempting to use the domestic courts inside Kosovo itself for prosecution of crimes. And indeed, in Mitrovic, one of the cities inside Kosovo, there is currently an individual who has been indicted and being tried for committing acts of genocide. Again, notice that the range of charges and indictments is restricted to those of an internal armed conflict. The OSCE has become involved in this, sponsoring seminars through the Kosovo Judicial Institute to train judges inside Kosovo to facilitate more effective prosecution of alleged criminals. There have been 7 prosecutors, international prosecutors, appointed to these courts, these domestic courts in Kosovo, and 3 international judges. If I can just sum up what I see as the position of military and legal engagement and intervention, I would say that the military intervention has been illegal but rather effective. The legal intervention has been legal but not terribly effective up to now. I have a few more comments of a general residual nature. I don't know whether you want me to stop at that point or return to that. Probably 3 minutes. All right. There's 2 residual things that struck me as I was doing research on this paper. One of them is that if you take a look at the NATO treaty that was ratified 50 years ago by NATO governments, there's a tremendous congruence between NATO and its deference to the UN Charter. But when you take a look at NATO's action, I think its actions is really out of step with the NATO treaty itself, and a fortiori out of step with the UN Charter. And so there's that kind of dissonance that I think is very intriguing, and one can't help but wonder what is the evolutionary track of NATO alongside the United Nations here. The other question, or other point I want to make of residual nature is really a question: where are we going in Kosovo? That's, I think, a very serious question, and it relates to the whole issue of effectiveness that I have partly addressed here. It relates to it because if our intent here is to stay in Kosovo for a while and then grow weary of the operation and bail out, it's very possible that we're simply going to witness another imbroglio in the region with other countries being drawn in, and who knows but the possibility of further ethnic cleansing. And I think if we tie that into general considerations, normative considerations, the concern I have is that we have been attracted to a kind of Kantian image of assessment of actions in a region of intervention, so that we give emphasis to issues of justice and rights, promise-keeping and truth, and we forget a very different tradition, a normative tradition, the utilitarian tradition, which I would otherwise name as capacious consequentialism. And I think that we have to balance these two traditions, and certainly not neglect the tradition of David Hume, John Stuart Mill, and Jeremy Bentham, which emphasize consequences, not just issues of rights. I don't mean to diminish the importance of rights, but I think if we're going to adopt an effective strategy for this region, we have to be in there for the long term and be very embracive. All right, I'll stop at that point.
Thank you. Thank you, Brian. I would have 10 comments to make, but I reserve them for a little later. And of course, I'm sorry that your own personal intervention with the UN office in Kosovo failed terribly. I think you raised, Professor McCullough raised a couple of very important questions as to the nature of intervention. And before getting to East Timor, I would like to make a few observations. I think that a lot of the discussion, as we could also see today again, focuses on the use of force. A lot of the discussion on intervention focuses on the use of force. I do think that in the first place and for future missions, we have to come to a much more coherent and comprehensive understanding as to what an intervention actually is and entails. And really the military part, the military campaign, as we could see in Kosovo and also to a lesser extent in East Timor, is really only the first aspect, the first step. An intervention is the entire effort that subsequently entails the civilian implementation efforts. And as one of the aspects, important aspects, is what you called the legal intervention. The reason why I'm saying this is that a lot of support, financial support, and attention is given to the military effort, whereas we could see in Bosnia, in Kosovo, and also in East Timor, the three contexts that I know best, that the civilian, the support, the financial, the staffing, the funding support for the civilian part, the segment component of the intervention fell way short of the support that the military intervention enjoyed. To come to Kosovo and East Timor more specifically, it's unimaginable, I would say, what the amount and the scope of tasks this civilian implementation effort entails. We commonly now refer to the task of nation building. We invented a new phrase to distinguish it from the traditional peace operations, and then we expanded this concept into peace building. But really, for these contexts like Kosovo and East Timor, even though the phrase peace building falls short of what it requires, it's really a nation-building effort in all its aspects. And let me just read out a few of these aspects to you. It entails, and it did in both cases, the complete recreation of the judiciary. It entails the rebuilding of the entire public sector, including the reconstruction and operation of public utilities, ports, airports, and the public transport system. You have to establish a functioning civil service, requiring the selection and payment of civil servants, create a network of social services, including employment offices, healthcare, rehabilitate and maintain road networks, ensure the provision of primary, secondary, and tertiary education, create the right conditions for economic development, including the establishment of a banking system, formulation of budgetary and currency policies, attraction of foreign investment, and the establishment of a comprehensive tax, customs, and levy system. there are many, many more efforts that I could mention, and I don't want to sound defensive or apologetic, but I do think that it's important if we talk about intervention that we bear in mind that all these tasks and many more are part of this intervention effort, and that the intervention does not stop with the cessation of hostilities. This being said, let me turn to East Timor, and as I only have a few minutes, I would like to focus on the intervention efforts in the judicial and legal field. I'm not sure to which extent all of you are familiar with the East Timor crisis. Just a very brief wrap-up. In 1975, Portugal withdrew from East Timor. East Timor was drawn into a brief but vigorous civil conflict between different parties in East Timor. One of these parties requested, quote unquote, the support of the Indonesian government, the Republic of Indonesia, and on the 7th of December 1975, Indonesian troops coming from West Timor, which is still part of the Republic of Indonesia, entering East Timor and establishing a regime that has never been recognized by the United Nations until the Portugal and Indonesia, sponsored by the United Nations, reached an agreement on the 5th of May 1999 to allow a popular consultation of the people of East Timor as to whether they would like independence or a final autonomy status as the 27th province within Indonesia. This popular consultation took place on the 30th of August 1999, and with an overwhelming majority of 78%, the East Timorese people decided for independence. Basically, hours later, an enormous violence erupted, unrest erupted, with the involvement of Indonesian security forces, not only the military, but also the extensive police apparatus and vigilantes, and supported by militias that were mainly recruited from among East Timorese that were more sympathetic to an integration of East Timor into the Republic of Indonesia. On the 15th of September, the Security Council decided to allow an Australia-led multinational force called INTERFET, the International Force for East Timor, to enter East Timor. Basically, before the Security Council resolution was adopted, the consent of Indonesia, the Indonesian government, was obtained, and this is a big difference to the intervention in Kosovo. And on the 25th of October 1999, the Security Council subsequently established the United Nations Transitional Authority for East Timor, with the ultimate goal of leading East Timor into independence and establishing the necessary administrative functions of East Timor. Among those functions is the administration of justice. And let me just read out the Security Council mandate to you. UNTAED, which is the acronym for the United Nations Mission in Timor, is entrusted with overall responsibility for the administration of the territory of East Timor, and is specifically empowered to exercise all legislative and executive authority in East Timor, including the administration of justice. Now, that's a sweeping mandate, but the reality is very different. It's very difficult to administer a justice system when there is no system left to be administered. mean virtually all judges, prosecutors, and court-experienced lawyers had left East Timor when the United Nations came back or UNTAD was established. There was not a single lawyer who previously practiced law in court or practiced as a judge or prosecutor. The entire previously existing digital infrastructure was destroyed and devastated. There was not a single court building left. Even the burned walls were stripped of all the wiring in every single outlet. There was no furniture left. The entire equipment, furniture, registers, records, and archives had been taken away or dislocated or burned. So when we talk about starting from scratch, I think no situation befits this term better than East Timor. This was starting from scratch or even if possible below. There were no resources whatsoever. Let me just quickly go through the three main challenges. There is a myriad of things we were faced with, and I just mentioned a few, or they're inevitable or self-evident from what I said before. You have to select and identify judges and prosecutors. You have to provide judicial training and mentoring programs to these people. You have to establish a legal aid scheme and an expert pool of public defenders. You have to establish a mechanism to address land and property disputes. You have to identify and train sufficient numbers of law clerks and secretaries who had also left with the outflow of the Indonesian administration and gentry. You have to bring back, re-establish law libraries. There was not a single law book left in East Timor. You have to establish professional legal institutions and associations, and many, many more challenges. The main challenges were the establishment of a legal framework, the identification and selection of judges and prosecutors, and as was mentioned before, the accountability issue, the establishment of an arrangement that would allow for the prosecution and eventually trial of those who were implicated in the violence of the 30th of August and even before. Let me quickly start with the legal framework. In regulation number 1, and the United Nations, as I said, was mandated to legislate in East Timor. In its regulation number 1, UNTAD decided to continue the application of the law that was previously applicable in East Timor, which was the Indonesian law, for a very simple reason: to avoid the occurrence of an immediate legal vacuum. Plus, the few lawyers, or not lawyers, but legal experts that were left in East Timor were all trained in Indonesian universities. But the formula provided, for a variety of reasons, didn't provide an ultimate solution. Experience has shown that it's very difficult to apply. The regulation says that the Indonesian law applies insofar as it is not inconsistent with human rights standards. Now, when you look at the criminal procedure code, for example, of Indonesia, that allowed for 20, 40 and more days of detention without a judicial hearing, it's fairly easy to say or to determine that this is in contravention of international conventions and standards. But it's a very different thing to actually tell lawyers what then, positively speaking, is the standard to be applied. And you can take an entire criminal procedure code and go through it and determine left and right what is incompatible with international standards. But on some of these issues, even international law is not very clear. The European Court for Human Rights is not entirely clear what the standard is to be applied. So for this reason already, the formula proved not to be very practical. Secondly, we had to obtain the legislation from the exact authority, Indonesia, that we had just helped to expel from East Timor. So you can imagine that the willingness was not terribly great to support our efforts. I have to rush, that's why I'm skipping a few things, but let me quickly move on to the identification of judicial personnel. As I said, there were no experienced lawyers left. Yet, Interfed, the Australian force, had started to arrest militia members who were implicated in the violence. They couldn't simply let them go free because we would have lost credibility on the first day of our mission with the East Timorese people. Plus, as you can observe also in Kosovo and in many of these contexts, in the immediate post-conflict situation where state institutions very often have collapsed, crime flourishes. You are faced with a situation where you have to react swiftly and be seen as reacting swiftly to this emerging challenge of a law enforcement vacuum. So we had to identify lawyers or legal experts who were capable of filling this. An established pool of international lawyers was not at hand. And you mentioned yourself, Barry, that in Kosovo now we have 7 international prosecutors and 3 international judges after 1.5 years. And let me share with you, these lawyers need close protection 24 hours a day. And I think there are about 40 UN civil police officers there to provide close protection round the clock. So you can imagine for these few lawyers what an enormous effort this is. What we did is, with the help of Interfed, we dropped leaflets from airplanes. We involved the Catholic Church to actually see where you have at least people who've obtained a law degree, who completed law school, although they've never worked in a legal profession. And after a few weeks, we identified 60 East Timorese who at least had obtained a law degree, virtually all of them at a university in Indonesia. None of them, as I said, was experienced. We had to appoint them to provide an opportunity for those who were arrested by Interfed and subsequently by the United Nations Civilian Police Force to get a judicial hearing, to at least issue a detention order, to give legitimacy to what we were doing in the law and order area. Obviously and self-evidently, this requires a strong focus on training and mentoring, not as a supplementary effort, but as a core, hard issue of the mission that with a view to capacity building. Let me quickly come to the last issue, which is accountability. From the first day of the mission, it was clear that those militia members who were returning, who were still in East Timor, we had to do something with them. Some of them were arrested by Interfed, others were coming back with the backflowing refugees, and the population identified them to us. So we had to arrest them. Arrest is a fairly easy thing if you want to avoid a situation such as in Rwanda, where years later tens of thousands of people are still in detention without a trial or a hearing. You have to establish a mechanism. As all of you know, the UN Commission of Inquiry suggested the establishment of an international tribunal. The Security Council declined to establish an international tribunal at this time. Thus, we had to identify a domestic mechanism, which we did. We established panels, mixed panels, composed of 2 international and 1 East Timorese judge at the district court in Dili, the capital of East Timor, with jurisdiction throughout East Timor to hold people accountable for genocide, crimes against humanity, war crimes, torture, murder, and sexual offenses. Now, this being said, as was mentioned before, you also have to think, when you think about justice, you also have to think about reconciliation. And one of the important aspects is amnesty. A discussion about amnesty has to take place because you won't be able to try hundreds or thousands of people. It's simply impossible, particularly not with the resources that I just mentioned. Plus, in East Timor, different from Kosovo, you have another issue, how to use traditional and customary law, alternative dispute settlements, which are spread all over the island, to actually involve them in reconciliation and justice efforts. I'm going to skip all my observations and recommendations and keep them for the discussion. Thank you very much.
We attacked everybody. We feared nobody. We were very bold. Everybody is knowing our tempers. This rather horrific wartime haiku, if you will, comes from a fellow named Joseph Sona, who is described in the Boston Globe Report as a 19-year-old veteran of the Sierra Leone Civil War. The force of I'm sorry. Is that better? All right. The four statements reflect the reasons that Sierra Leone has become notorious among our conflicts. We attacked everybody. The campaign, particularly by the Revolutionary United Front, the major rebel group, was a campaign of terror against civilians. Beatings, summary executions, an estimated 20,000 people kidnapped in a 9-year period, many of whom have never been returned to their homes. Systematic rapes of girls as young as 5, women as old as 75, numbering in the thousands. The creation of a refugee and internally displaced persons population of 1 million, that's a quarter of the population of the country, and perhaps more notorious simply for its peculiarity to this conflict, the cutting off of the hands of people who had dared to vote for the president in 1996. We were very bold. Sierra Leone is known for its use of child soldiers who also, in many cases, are child victims. The numbers estimate somewhere between 5,000 and 10,000. They were recruited by both sides of the conflicts, the rebels as well as militia who favored the government. Joseph Sona is an old child soldier in that he was 19. There is documentation for children as young as 7 serving in combat. They came to combat sometimes out of disaffection. They were kept there by the use of terror and drugging. Many of them were kidnapped and forced into service. Many of them were forced to stay because they were tattooed, and once they received an RUF tattoo, their families would no longer take them back. Everyone is knowing our tempers. Sierra Leone is very unusual in that for those of us who look for an explanation of a conflict, there seems to be none. The conflict has no roots in ethnic division, racial division, religious division. The RUF is an organization with no ideology and simply exploits disaffection among young people and then enforces their disaffection through terror. Its only reason for being, as far as I can tell, is to continue profiting from illegal diamond trading, and its only reason for waging the battle is the joy of doing evil. We feared nobody. Sierra Leone is notorious for the grants of amnesty for the people that did these things. Amnesty has been granted not just once, but twice. Once in the Abidjan Peace Accord in 1996, and again in the Lomé Agreement in 1999. I've been looking recently at something called the expressive theories of law. Those are theories that look at not whether law deters or whether law punishes, but what's the message that we get from law. And I think that that theoretical basis is very helpful in looking at things like what happened in Rome. Expressivism tells us that a harmful message in itself causes harm, and tells us that when we evaluate whether what was done was good or bad, we should look at the message that was being sent. I'm going to do that by looking first at the Lome Agreement and then at the post-Lome proposals for resolution in Sierra Leone. The Lome Agreement came in 1999. It had been preceded by, I believe it was 8 years of civil war. There were a number of coups in that 8 years. At one point in 96, Sierra Leone experienced its first democratically elected president in 30 years. He immediately negotiated a ceasefire, and that led to the Abidjan Agreement in 1996. That agreement promised total disarmament, amnesty toward all people. It collapsed almost immediately. There was another coup. The president eventually was restored to power with the help of Nigeria. And then in 1999, it was another very, very destructive attack on the capital, Sierra Leone, Freetown, led to a new ceasefire and finally the Lome Agreement in July of 1999. It looks, in some respects, a lot like Abidjan. Promises immediate and full disarmament, demobilization, and integration. It includes sweeping plans for reconstruction, the establishment of many, many commissions to restore civil society, the Human Rights Commission, the Truth and Reconciliation Commission, the Election Commission, the Constitutional Review Commission. It talks about turning the RUF into a political party. And then the real key, I think, to Lome, and the thing that was most remarkable to me when I first read it, is that it grants by name the following to Foday Sanko, who is the leader of the RUF. At the time that the Lome talks began, he was a condemned prisoner on death row in Sierra Leone, having been convicted of treason. He was freed and sent to the peace talks. He managed to negotiate the following language. In order to bring lasting peace to Sierra Leone, the government of Sierra Leone shall take appropriate legal steps to grant Corporal Foday Sanko absolute and free pardon. There was also an absolute and free pardon for all combatants. Sanko was not just free from liability, he was rewarded. He was given the chairmanship of a new commission for mineral resources, the one rich that Sierra Leone has, some say, source of the conflict in the first place, the diamond trade. He was to lead the cabinet post that would deal with that. And he was to have the status of Vice President of Sierra Leone, answerable only to the President. Lome sparked controversy almost immediately. The Secretary General lauded it as, quote, a great step forward for the people of Sierra Leone. He acknowledged that amnesty was difficult to reconcile with the goal of ending the culture of impunity. And he said, but we have solved that problem by adding a reservation. I must mention, the only evidence I can find of this reservation is statements by the United Nations. It is not attached in any form to Lome, where I have found it on websites and in publications. But I believe it happened, it just doesn't happen the way some reservations happen. He said that our reservation states that for the United Nations, the amnesty cannot cover international crimes of genocide, crimes against humanity, war crimes, and other serious violations of international humanitarian law. Outside the UN, in the US, there was a feeling this was the best deal we could get. In Sierra Leone, there was largely resignation. And I have another quote from a 68-year-old man whose house that he spent the first half of his life saving money to build his house, the second half of it living in it. By this time he was 68 years old and was found by a New York Times reporter hammering the cement blocks that were left of his house into pebbles so that he could sell them. And he said, we just have to forget, really. We just have to forget, nothing else. I have no power. Our leaders say we must forget. Am I going to refuse our leaders? We have to just unite together and build the country back up together. Finished, finished, that is all. NGOs were outraged at the amnesty. Several members of the State Department, notably the members who seem to have the briefs that deal with these issues, Secretary Coe in Human Rights, the humanitarian refugees, State Department people, all opposed the amnesty. Some characterized their viewpoint as the viewpoint of Western privileged individuals who didn't understand the needs of Sierra Leone. In my mind, the message here was clear. There was an ostensible message toward reconciliation, an admirable expression both in the preamble and the actual provisions of the Lomé Agreement of a desire to move forward, to reconcile, rebuild, reintegrate. It was, however, entirely obviated by the message that was given by the amnesty provision. The amnesty provision specifically, this, as far as I can tell, unique grant of pardon to a named individual, told the world that all talk, at least in Sierra Leone, all talk of the new era of accountability was just that, just talk. That atrocities will not be punished. That perhaps if they're effective enough, atrocities will be rewarded. And then I think the subtextual message was the West doesn't really care and doesn't have the political will to do what needs to be done in Sierra Leone. Well, after Lomé, Foday Sankoh at least got that message. He stalled, he objected, he obfuscated much of the behavior that he had engaged in after the Abidjan Accord. When Secretary Albright came to see him, he showed up 2 hours late for the meeting. When he made public statements inciting people not to disarm, and then when the Secretary General of the UN met with him, he said, oh, but I support the peace agreement. So he was duplicitous throughout. People started to be taken hostage again as early as October '99, just a couple of months after Lomé, and almost immediately after Sankoh returned to Freetown, the capital. By May of 2000, as we all know, everything fell apart. 500 peacekeepers of the United Nations were seized by the RUF. Sankoh was arrested, but those hostages were held for months thereafter before their release was negotiated and sometimes engineered through commando operations. Well, I must say that there is a chance now for the international community to do better. There is a proposal for a special court for Sierra Leone. In June of 2000, Sierra Leone wrote a letter to the Security Council or to Secretary General asking for such a court. In August of 2000, the Security Council authorized the Secretary General to negotiate an agreement to establish such a court. And in October of this year, October 4th, the Secretary General submitted his proposed agreement and draft statute to the Security Council. It sits there now under consideration. The contents of the draft statute address some of those notorious features of the Sierra Leone Civil War that I mentioned before. With regard to the RUF campaign against civilians, it would set up a victims and witnesses unit. It calls for fair trial rights that must be balanced against victims and witnesses' needs for protection. It calls for staff, judges, and investigators who are trained in issues regarding juvenile justice and sexual assault. It provides for 3 articles that would allow prosecution for international humanitarian law violations, crimes against humanity, war crimes, serious violations of international humanitarian law. I should note that with regard to the violence against women, it specifically says in 2 of the international articles that there may be prosecutions for rape, sexual slavery, enforced prostitution, forced pregnancy, any other form of sexual violence. And there is also, it's a mixed tribunal, so there's also an article that applies Sierra Leonean law, and that applies to certain offenses regarding abuses and kidnapping of girls. With regard to the problem of child victims and child soldiers, first of all, it makes it a crime to kidnap or forcibly conscript children under 15 for the use in combat. Most notably, and probably very controversially, it provides a juvenile chamber to prosecute children who were involved in combat. Children who were between 15 and 18 at the time that the alleged crimes were committed would have proceedings by a juvenile chamber presided by at least one judge with juvenile experience. There is a possibility of those being in-camera proceedings, of the children's identity remaining anonymous. They would not be sentenced to jail, but be given dispositions, to use the term in the statute, that are largely rehabilitative. There is also, let me step back. The Secretary General's report attached to the statute recognizes that this causes what he calls a moral dilemma, that there is a feeling in Sierra Leone that these children cause some of the worst things that happen to us. They must be held accountable. On the other hand, outside Sierra Leone, the NGOs in particular are outraged at the idea that there would be any tribunal with international sanctions that would be prosecuting children. And so what he said is, here's the statute, here's the language, I'm punting to the Security Council and you can decide if you want to go forward and do it. With regard to the idea that it's very difficult to figure out why the people in the RUF and the other rebel groups were fighting, there is this notion, particularly with regard to child soldiers, of trying to find alternative sentencing, rehabilitation, reintegration. Also, with regard to child soldiers, there's a recommendation that their cases be referred to the Truth and Reconciliation Commission if it ever starts operating, although they will remain an option of prosecution. With regard to amnesty, the special court statute minces no words. In Article 10 it says, an amnesty granted to any person falling within the jurisdiction of the special court in respect of these crimes, the international crimes, shall not be a bar to prosecution. So it simply says the amnesty does not apply. It also incorporates another new message about accountability. It starts the clock for jurisdiction at November 1996, the date of the Abidjan Agreement. It has no finishing date, much like the ICTY. And so it suggests that to individuals who might be contemplating crimes, that this court will continue to be observing and considering prosecution for what they do. The message then is stronger. It suggests accountability. It allows flexibility for some of the situations unique or peculiar to Sierra Leone. There remains to be seen if it will be established. The initial Security Council resolution suggested voluntary contributions. The Secretary General's extremely conservative estimate for the first year of operation is $20 million. I think that's very conservative. The ad hoc tribunals operated about $60 million a year, and the financial mechanism is very, very dim, so we don't know if this is actually going to happen. I think it's important that it be tried. I should say, I mentioned at the beginning, one of the unique aspects of the Sierra Leone conflict has been this practice of chopping off hands of the people who chose to vote. It's not really unique. It's something that was borrowed from the Belgian colonizers who would chop off the hands of people who didn't work fast enough in the rubber plantations. The people who did that in the last century were never punished. Sanko took that practice, infused it with new meaning, and used it for a new round of terror. I think it's time that cycle of violence stopped. Thank you.
We have approximately 15 minutes in our formal time, and we did want to leave time for questions from people observing the panel. I initially contemplated saying a few words about what's happening with Cambodia right now, and perhaps very briefly, and it's difficult to squeeze what's happening in a country like that in 5 minutes, but what I would propose to do is, for those of you who may not be familiar with the current events in Cambodia, there has been a process ongoing for approximately the last 4 or 5 years to establish an international criminal tribunal, or some form of criminal tribunal, to bring to account at least senior officials with the former Communist Party of Kampuchea, or the Khmer Rouge, who ruled in Cambodia in the 1970s. And at the current time, the process is quite unclear. There had been a recommendation made by a group of experts appointed by the Secretary General of the United Nations to establish an international tribunal very much like the ad hoc tribunals for the former Yugoslavia and Rwanda. And that the report from the group of experts came out at the beginning of last year. Since then, the Cambodian government rejected the proposal, and the United Nations and the Cambodian government have been engaged in a series of negotiations about the establishment of a domestic tribunal, as we understand it now, under Cambodian law, that would involve some form of international participation. And at this stage, it's not entirely clear whether this tribunal will be established, and if it is, what the jurisdiction of the tribunal will be, who the potential defendants will be. But what I think is interesting about among other things about the current developments on Cambodia, is that to some extent it highlights the difficulties that are posed when the international community does not intervene in a conflict or a situation in a country at a time when atrocities are about to be committed or are committed. Because in the context of Cambodia, the international community is having to reach back 20 years to between 1975 and 1979, which was a time period when most of the atrocities were committed by the Khmer Rouge. And some estimates placed the number of casualties at almost 2 million for the number of Cambodians who died while the Khmer Rouge were ruling Cambodia. The difficulties posed bringing individuals to justice now are numerous, and some of them can be tied back to the fact that there was no intervention at the time that these atrocities were being committed. Among them, for example, one that I'll highlight is really the credibility of the international community, because the international community never intervened, and in fact, after the Vietnamese had taken over Cambodia in 1979, the United Nations, or at least the United Nations mechanisms, retained the Khmer Rouge as the official seat of government for Cambodia. That dealt credibility to the United Nations and the international community, and the Cambodian government has raised that fact as part of the environment in which negotiations over a tribunal have taken place. So the international community has been in a weaker position than it has in other more recent conflicts where they have actually
Hi, welcome to another show, another program of Pro Se Views. Hundreds of thousands of people are representing themselves in court because lawyers are too expensive or because people simply do not trust them. We have a camera in the court program here on Pro Se Views simply because pro se litigants are experiencing bias in court cases, allegedly partially due because they are unprepared, but very often due to the political nature of the cases that are brought by pro se litigants. Here in seat 1, why don't you pan to seat 1 with the, just get a shot of seat 1. And right, if we can get a picture of that guest. I think you need to, well, you've got one, you can see that, well, that's seat 2. And you can see that seat 1 is empty, and that is a seat that was reserved for a state Supreme Court judge who has decided not to show. There was also a seat next, that one, seat 2, for a prosecutor who, from New Jersey, who is not here. Next to seat 2 is Sean Cunningham, and Sean, would you give the audience a bit about yourself?
Well, thank you, Shank. I'm glad to be a guest here this evening for Pro Se Views. I am a producer and news director of Access News, which is going to be debuting here on Manhattan Neighborhood Network's Cablevision on Channel 34. I'm glad to be a guest here. I'm a working journalist, so I have a lot of opinions about the subject or the issue of cameras in the courts, and I'm going to be throwing some ideas out there from the media's perspective and helping, I guess, the viewers kind of help to decide for themselves how they feel about this issue and why they are for or against this very hot issue. So thank you for having me.
Seated to my left is Erwin Eisenstein, and Erwin, why don't you give the folks a little history about yourself?
Okay, I've been involved in several court cases. Some people would say I'm litigious. Judges might, although I don't think I would consider myself litigious.
And what does litigious mean?
That means you want to get justice in the courts, and you can't get justice as long as those courts are closed. As long as you don't have jury decisions, judges make law. And when judges make law, they're more likely to favor any organization, whether it's members of the bar, whether it's police, whether it's other, judges or attorneys. And my position is that cameras in the courts that would broadcast would help people who aren't attorneys represent themselves. The United States Supreme Court has said in many decisions, one of them being a civil rights case, NAACP v. Button, that people who are members of a group can assist other members in a court of law. Classic case, Gideon v. Wainwright, which related to the a person being assigned counsel, also had dicta. And what dicta is, it's an opinion, but it's not law, by the Supreme Court that said that you can't expect people who aren't attorneys to function against someone who is an attorney. And because of that, the court said they should get help. And whether that help is an attorney or a member of a group who has a common cause with them, they should be able to have that person sit with them and assist them, and possibly even to talk for them at times in a court.
Now let me stop you right there, because you brought up the subject of closed courts, and the family court has just recently been opened by Judge K. Now,
I'd hate to contradict you.
Okay.
I really would.
Mm-hmm.
Judge K has said that the courts should be open. However, each judge still has the right to bar and to ban people from those courts.
Well, have you been personally banned trying to get into...
Absolutely. In fact, I wrote letters to Judge K, and she passed them down to Michael Gage, who is the administrative judge in Manhattan. And what I said was, each courtroom...
What did Mike say?
Okay, Michael Gage, who's a woman, by the way, said that they're not yet ready, and they really haven't established rules, so that each judge and each guard in front, who's called a bailiff, makes up their own rules. Some will ask for identification. Some will allow you to say, well, if you want to go in, the court is too crowded and you can't go in.
Now, I see you have an article there by Nat Hentoff from the Village Voice. Is that right?
I don't know. I just received this, and
Okay.
I'm going to read it in the future, but yes, I do.
Now, I don't know if we can get a close-up of this. I wonder if we can get a close-up.
Well, why don't you just hold it and read it, Shane?
Of this picture. Can you zoom in on this? Now, yes, there we go. That crack cameraman. We've got Joe Friendly on the cameras. Now you can see here, it says, I don't want to get involved. Now, below, you have, it says, and I'm doing this backwards, but it says CPS, and there's a child, but you can tell this is a military style or police type person, and this police type person is taking the child in that direction, while this other, it says police, it clearly says police, is taking the mother in the other direction. Up top you see here it says, I don't want to get involved. And if you can make out this lettering here, you have legislators, Justice Department, ACLU. And these are the people who do not want to get involved in, and we can go back, and this is a live show, so we will welcome your calls. These are the people that don't want to get involved in the separation of children from their mothers in family court. Now, I have a program which I'm personally just running, and I pass out the law of Family Court Act in Article 10, and it's called 1028. It's a 1028 hearing. Now we have a roll-in for you, and I'm going to describe what's happening in this roll-in, which was just taken 2 days, rather yesterday, as a matter of fact, or was it Friday? It was Friday, just taken Friday, and I was out handing out the law to people because in family court, people go in, they don't know their rights, no one tells them their rights, lawyers don't tell them what their rights are, they're not being told that they can bring witnesses. You see, and we have this roll-in coming for you in just a second. Yeah, do that roll-in, okay, and here it is.
We started this when we came, come right on over here. Step right there. Now, you said that they took your kids yesterday. Now listen, this, step right up, more closer to the mic. Let her talk because they took my 2 kids away, so now I have 4 kids. They took them because my son was outside playing with another boy who got beat in the head with a rock. You understand? So I told them that at the school what happened, and the school called ACS and the police on me, and they went to my mother's house. After I left the Manhattan, they went to my mother's house. They went me and they took my son away. Now they're trying to take my son away. 1 year old and 6 months old. Now listen, this is what I got here.
What happened in that situation was one child. We have a live call. I'm going to take this call and then get back to you about what that roll-in was all about. Caller, hello? Are you there?
Hello.
Yes.
My name is Don Allen. This is concerning criminal court. Okay. I need to know whether is it mandatory for a grand jury to play a part in the criminal court? Because I feel that the judges, and the DA themselves. I'm a recent.
When you say play a part, what kind of a charge are you talking about?
Because as far as you're going into court and you're not really understanding the law itself because the DA is not explaining it to you, okay?
And neither is your lawyer.
Neither is my lawyer, okay? You don't know the judge's qualifications.
Well, if you are charged with a felony, a grand jury has to hear the case and decide that a trial should happen. So, I mean, that has to happen. A grand jury has the right, to ask questions of the district attorney. That grand jury is not the property of the prosecutor. That is an arm of the court.
Due process.
Yeah.
That is an arm of the court.
Let me raise an issue here because...
And I think grand juries should have cameras in those courts as well, but go ahead.
Okay.
Go ahead.
One of the issues with grand juries is they're the one who bring an indictment. And what's interesting is they bring indictments based upon the information that's presented or not presented by a prosecutor. Mm-hmm. And I've been involved in several actions where police were involved. And in those instances, I felt that the prosecutors didn't present information properly in front of a grand jury. And effectively, I felt that the prosecutors were there to protect the police rather than have them accountable for things that they did improperly.
Now, Sean, as a journalist,
Yeah, I wanted to interject by saying I think it goes back to what you were saying, Mr. Eisenstein, about judges and bailiffs taking it on their own individual. I think let me play devil's advocate by saying I think they're taking it on a case-by-case basis.
Why should they? Why should any bailiff function as a judge to restrict any person from going into a public court?
Well, let me say, as a journalist, I mean, I'm all for freedom of the press. I'm in favor, as a journalist, for cameras in the courts because I think that's what this whole system of being a democracy is about, freedom for everyone. But at the same time, I think, playing devil's advocate, they're hoping, let's just say, giving them the benefit of the doubt, of trying to be cautious, depending on a case-by-case basis. For instance, the most famous case recently where there were cameras in the courts is the O.J. Simpson trial.
That's right.
And a lot of people would say that having cameras in the court system did a detriment to the whole trial. It helped to make it more scandalous. It helped to make
That's
it more.
nonsense.
It
Okay.
helped,
That's
well,
enough.
well,
Let me say this.
helped to make it more
That's nonsense.
scandalous. Helped to make it more sensationalized.
but doesn't everybody
And-
have a right to go into that courtroom and see the proceedings, to see that justice is either done or not done?
In the
How's it?
bombing, the Oklahoma bombing case, although it was not telecast to the public,
Right.
it was telecast to the many people who were associated and related to victims.
That's what I was going to say.
Now-
Maybe if you differentiate, I mean, for instance, for regular working journalists, I am in favor of the idea of cameras in the courts. But for, say, Joe Schmo, who's taken a personal interest in a trial that he's read in the paper, and he has a personal curiosity about it, for him to take a camcorder and for him to consider himself a working journalist and go down there, I'd have to, I mean, I'm playing devil's advocate here. I mean, there's a difference. There is a difference.
Let's hold this for a second. I want to take this live call. Caller, can you hear me? Caller, are you there?
Yes, sir.
Try that one more time. I couldn't hear your
Good
voice.
evening. How are you?
I'm fine.
Good. I tend to agree with the young lady with regard to cameras in the courtroom. It should be case by case. And if you look at the O.J. Simpson trial really closely, you will see that many of those people played for the cameras, and it didn't have a lot to do with justice.
Well, let me ask you this question. You know, going from the O.J. case. Now, did you see that roll-in that came up a little while ago?
No.
You didn't see the roll-in?
No.
Well, let me explain to you what happened in that roll-in. In that roll-in, there was a young lady talking to me outside the family court building. A child number one, threw a rock at her child number two.
Right.
Now, child number one told her grandmother that she threw the rock at child number two. So when the woman who was in the roll-in came to court, she brought the grandmother, she brought a few other witnesses. Now, in family court, hearsay is admissible. That is, if the child tells the grandmother something, the grandmother can just come in and say the child said that because hearsay is admissible. The woman's lawyer did not call the grandmother to the witness stand in what is called a 1028 hearing. The girl's lawyer did not call there was no paperwork entered into evidence, there was no testimony whatsoever. If there was a camera in that court, that lawyer, who I think could possibly be sued for malpractice, would have called the grandmother, would have introduced the report card, would have introduced clinic records, would have brought friends and their friends, and that's why cameras are needed to protect people who don't know the law, who are not being explained the law.
But who should be wielding those cameras? Are we talking about, say, someone who works for Access News or the New York Times, or, for instance, those who work for, say, all of the, I mean, since we're cable access, for instance, but not everyone who works, in, no disrespect to the wonderful producers who work for cable access, I mean, qualifies them to be an objective, qualified working journalist. So who should be wielding those cameras?
Here's the issue. The issue is, why would you restrict cameras from any court? And this has happened, and it happens in most live broadcasts, usually journalists tie in,
Right.
and you can have 20 different journalists tying in to one camera. So all you really need is one camera in the court. But that's not the issue. The issue that was raised was who determines when you have cameras or when it's telecast and when it's not telecast. And that's an entirely different issue.
But I think
now,
they have
are you
to.
going to let a judge make that determination? Now,
If
my position is the only people who should make, if it's, and I think this is, I'm off, but if there's an issue related to who should determine,
Right.
if there's a defendant, the defendant should determine, and not the district
obviously,
attorney,
let me tell
and
you
not the judge.
Obviously, if, for instance, if he's going to have, if a judge knows ahead of time he's got a sensational court case pending on his desk for the next couple of months, obviously the defendant, playing devil's advocate again, obviously the defendant is going to want the cameras there. He could be guilty or not, but obviously he wants it there for his best interest, I mean, so that he can play, let's just say he's the best actor in the world. He can play on the sympathies of the public that's watching, play on the sympathies of the public that's watching to help him get off. So we're not talking about due process. We're talking about doing whatever tactics that you need to get you off, get you scot-free.
We have a call, and call, I want to ask you a question. Isn't it up to the jury member to decide whether or not that defendant is playing to the camera and should not be believed, or whether that defendant in that, or whoever's in the witness stand, is actually being truthful and should be believed? Isn't that up to the member in the jury box?
Yes, because that is his job, after all.
Come again, start again?
Yes, that is his job, to make that determination.
You're saying that is up to the jury member to decide whether or not a person is playing to the camera or exposing his true feelings?
Well, see, see, that's not something that he's there to determine whether or not the facts will lead to his guilt or innocence. But if you have cameras in the courtroom, not only do you have defendants playing to the camera, you have lawyers playing to the camera. And this, I do believe, depending, again, upon a case-to-case basis, will impede
Well, aren't
the
you
justice
intelligent enough to see through somebody playing to a camera, or even if there was no camera? Lawyers have been known to play to the jury.
People have been debating that even after the O.J. Look, the guy was by law declared free or not guilty. But look, even after, I mean, I'm not going to state my opinion as far as that case, but even after that case, he's on trial again. He's going to be on trial for the rest of his life. And as far as jury members not supposed to help a defendant play to the case, some of the jury members themselves, forget about lawyers and the defendant, some of the jury members tend to play up to the cameras. I mean, they had to, how many juries did they have to get rid of before the case was heard? Now a jury member was, I guess, what is that? She took her clothes off, or she had to deal with Playboy. Yes, you were called so that you can help the process of democracy and due process of law. Yes. And then they go into your background and something happens, and now you're doing an interview and you're taking clothes off for Playboy. What does that have to do with this person on trial?
That's an exceptional case. The O.J. case is an exceptional case.
Right.
In most cases, that doesn't happen, and jury members, even if they play, are playing for a very limited audience. The question is, do judges act differently? Do lawyers act differently? Absolutely. In most instances, they show more respect to non-attorneys when they're representing themselves, and that's the issue.
Right.
As to juries never get all of the evidence because judges exclude evidence. Judges effectively limit the amount of information that is presented to the jury. And in many cases, judges make decisions that aren't just. I've been excluded from testifying as a witness at several trials, and there was no reason given. I was testifying for a defendant in some cases. I've seen one judge, a federal judge in New Jersey, Catherine Hayden, explain to a lawyer what a Batson challenge is. Let me explain it to you and for the members of the audience. If an attorney excludes members of a jury or takes them off the panel because of their race, that's called a Batson challenge. I was helping a person select a jury, and the attorney representing the police took a black guy off who had dreadlocks. And I then made a challenge to the judge. And this attorney said, "What's a Batson challenge?" Which was, to me, was outrageous. Right. Now, one of the issues is the judge acted inappropriately also, because that judge, once a challenge is made, has to ask that attorney why he excluded that juror. It never happened.
No one's questioning whether our legal system is flawed. I think we all live in this country. We all pick up the newspapers. We all know the realities of living in this country and the flaws that we have in our legal system. No one's questioning that. However, I just believe that the situation, cameras should be held with the responsibility of working journalists, those that deal with it every day and who are trained with the ability to be objective and to kind of provide that sense of objectivity to the public. I don't think
you sound just like a lawyer. Listen, as a caller, let me ask you this question: do you think innocent people want a camera in the courtroom? Hello, are you there? Can you hear me?
Oh, yes.
Do innocent people want cameras in the courtroom?
I think so, because they could be in the same situation.
Can you turn that up in the control room, because I can't hear them out here? Caller, could you repeat that? Are we, well, I did hear the caller say yes, innocent people do want, yes, you're there.
Yes, I'm here.
Mm-hmm. Did you actually say that innocent people want cameras in the courtroom?
I think so. How about you?
How about me?
Yeah.
Absolutely no doubt. Absolutely no doubt.
they should be. I just think with some guidelines, that's all.
You see, there are thousands of people who are being just treated with no duty.
Hello?
Hello?
Can you hear me?
I can hear you.
Yeah, I'm calling in to answer that question, brother.
Go ahead.
You know, listen, they're so quick to, we're guilty before proven innocent anyway. They're so quick to splash our face on the paper. When we go back home, we're treated as if even if we beat the case. Because no one was there, they say, well, he got lucky, he got off because he was black or whatever, right?
Let me ask you a question. Do you think you should be able to see the Tawana Brawley defamation trial going on right now? Are you interested in that?
Well, to be honest, no, I'm not really interested in it. But I think for her benefit, that it should be shown. You understand? It should be exposed because again, the press has a way of smearing things, of distorting things.
So what you're saying is that when there's a camera in the courtroom, the evidence cannot be spun as easily.
Brother, you said it terrifically.
But when anyone has the ability to take a camera, for instance, like I said, Joe Schmo from the neighborhood who has a curiosity in the trial, if he can just get his camcorder at home and decide to take it.
That's not what we're saying. Not at all.
Well, let me finish my question.
Well, it's not a question. It's
let me finish my
not
question.
a valid.
It is, because, for instance, if anybody has accessibility, if this is open to everybody, that's all I'm saying. If this is open to everybody, we lend ourselves to the possibility that it's going to get out of hand, basically.
No, that's not what we said. We said specifically.
The gentleman.
Let me finish, please. You've had your chance.
Okay, go right ahead.
Now, as a journalist, you're aware that one camera can give leads to any number of people recording. Now, I'm not saying that every journalist should be allowed to bring their own cameras. That would be a circus. That's not what we want. We want to have the ability to record each trial. The people who are there, the defendant, should be the person who makes the determination whether that camera is used and used by journalists. Journalists, we found, don't have the discretion to show a full trial. Obviously, people wouldn't be interested. They're looking for sensationalists.
We have a call on the line, and caller, I just want to put you into this conversation. Now, if you had a trial, caller, and you had recorded that trial on a camcorder, you know, you wouldn't have to spend money if you had to appeal in order to review the testimony.
True.
Now, do you think that a person should have the ability to reproduce this economic form of trial testimony?
And you're talking, every trial is not sensational. But I do agree that you could use it as a future resource, a reference point if you do have to appeal. But again, you know, it's proof. You understand? It's proof of what went on during the proceedings. You know, and something else too. I don't agree with just that there just should be one point of view. I mean, like the defendant should pick who has access to the recording and whatnot, because then they could say that the recording's biased. I think you should let as many in there as within reason. You understand?
What is that reason, though, caller?
Well, I mean, like you don't, like you said, you don't want it to become a media circus, okay? You don't want it to get out of hand, okay? But the reason why we have a court system and we have audiences in the court is so they can view the proceedings. But for some reason, when the information leaves the courtroom, it's all distorted. You have to be nowadays. You have to be so analytical in reviewing court proceedings.
You mean when you read them in newspapers?
If you read them in a newspaper, if you see the results on the news, you know, whatever, you understand?
So you'd rather see it for yourself?
I'd rather see it for myself, and I'd rather again have a video history of what went on during the trial.
Shank,
Okay.
I'd like to point out two things. Right now...
I have to go.
Okay.
Hey, God bless you.
Thanks a lot. All right. Peace and blessings.
Sean, you booming.
Okay. Sean, I don't have your, natural whatever, but the issues I'd like to raise at this point is, number one, the appellate courts won't allow you to use a video copy for an appeal. And what that does is if you have 1 day in trial, if you want to get a transcript, it's going to cost you $800 to $1,000. A videotape costs $10. That means that appellate court can review the bad decision by a bad judge.
You've got a minute more to wrap up, then we'll go to Sean, and then we'll kind of close out. You've got a minute more.
Okay, fine. I've been in court where I tried to present evidence like this to a judge, and he wouldn't accept it. So I did that. And he said, let the record reflect that I'm throwing papers at the court. And he held me in contempt. If that was on camera, I would have been able to show that that attorney who I was trying to show committed fraud did commit fraud, and that judge would never have gotten away with that, and I never would have been put in prison.
Sean Cunningham from Access News.
Just wanted to say I'm sorry that you had to go through that experience, Irwin, but I do feel that, again, I think that we should have cameras. I endorse the idea of having cameras in the courtroom, but only under the auspices of working journalists, those who are able and qualified to make those objective opinions, so that it doesn't get out of hand and turn into a media circus.
Well, we are going to jump right to these. I'm going to forego what I got to say. Caller, can you hear me? Caller, are you there?
Hello?
Yeah.
I think you're so fucking...
Okay. Caller's not there. Caller number 2, are you there?
I saw a very interesting special on Chris Rock, and he was meeting with the Reverend Jesse Jackson,
Yes.
and he had a great point. He said, why can't a black person just pick up the garbage in front of his front yard? Why can't he do that? Because Chris Rock had to pick up the garbage.
Now, what this caller was referring to was a case in which a FBI agent went in between someone's house to pick through the garbage in order to find evidence of a crime that had been committed. And the Supreme Court found that the agents were allowed to go onto private property in order to pick through this person's garbage. Now, that case was not televised, so we're not going to be able to talk about that. But this is Pro Se Views, and we'll be back to you in about 2 weeks' time. So until then, keep fighting, keep slugging away, cameras in the court.